says she can hear us. So we are now live on YouTube. It is Friday, April 23rd, 2021. And we are taking up an amendment to S-145 that is being offered by Senator Rahm. And the amendment
145.
J or TJ Duggan. I'm sorry, is being offered by Senator Rahm, and I'm going to let her explain the amendment, and then we're going to hear from John Campbell, I think Julio Thompson, and Mike Shirley. Okay.
Senator Rahm, do you want me to make you the co-host to share?
I think
Actually,
yeah.
couldn't Bryn share it?
Sure. Bryn, you're the co-host.
She drafted it. So.
Yes, I don't need that kind of responsibility in my life. Just sort of here to give a conceptual overview, and I really appreciate Bryn's help and work on this, as Judiciary is not my sort of native land here. But as I was listening to the debate and discussion yesterday around H-145, in kind of marquee lights, I was just seeing credibility as a big concern underlying the culture that you are trying to create with this bill of accountability around what is reasonable use of force for a police officer. You raised the murder of George Floyd as an example of why language like this would be helpful and important. And as you may have seen, the first report out of the police department was calling 3 officers standing on someone's back and occluding his airway a medical incident. In the case of Adam Toledo, the first reports before the body cam footage came out were around him having a gun in his hand. So Dante Wright, I meant to reach for my taser, and instead I reached for my gun. We have a question, I think, in this country and in this state around what an officer testifies to have happening in an incident, versus what we end up seeing and investigating around body cam footage and other evidence that we may have. As you may also be aware, there was a recent Human Rights Commission case involving Clemens Family Farm, where there were concerning allegations that a trooper was coaching essentially someone squatting on their land, and that was caught on dash cam footage and other video footage. And so, when I heard the discussion, it occurred to me that I had been working on language with Bryn around Giglio files and the ways that we have currently in statute to try and hold officers accountable to accurate and accurately represented information about incidents. What I have heard from several states' attorneys, who actually were the ones to raise this with me, is that there are agencies and local law enforcement departments that perceive in some way that this is somehow discretionary for states' attorneys to be adding information about falsified or misclassified information to someone's, disclosures or Giglio files. And as you probably know, this has a lot to do with their credibility to take the stand in a court case, including their ability to be a investigator on the scene of a crime for murders, et cetera. And we should take that very seriously. Their ability to be a credible witness on the stand, and if they've had those kinds of inaccuracies before in the information that they've presented. And so what this does, I think, is clarify that it is not discretionary for a state's attorney to disclose this information, that, they have a responsibility to disclose this information and to have it on file. And so, you'll hear more from Bryn about the ways that that would need to be embedded in statute in order for that to be the case. But I did have state's attorneys say they welcomed this change because it would stop law enforcement from, in some way, making it losing trust with law enforcement, because law enforcement is seeing it as something they would have discretion over, and that it should be clearer that they this is their duty as a state's attorney, and anyone in this, defending the state and the state's interests, that they have this information available. I think what you may hear, I did talk to the Attorney General this morning, and you may hear that it's in the interest of the Attorney General's office to try and at some point have this information in a more public repository or some kind of central location, which I think would be a logical next step. But what I'm asking for today is that we clarify that this is a non-discretionary piece of our justice system, that we know about officer misconduct and the misclassification or misrepresentation of information before we're giving them the benefit of the doubt about what level of reasonable force they used in a situation.
Dick, you're muted.
That was great. I was telling Senator White she's muted. And I was muted. That's a great Zoom. I love it.
So
Senator White.
I finally got hooked up. I'm not sure why it's echoing.
Do you have another device going, Jeanette?
I thought
Actually, you've got the other device. You're on twice, Senator White.
I thought I went off on that one.
No, it's still on. I think that's why you're mute.
Why would it still be on?
Do you want me
I
to
don't
try
know.
and remove it? I can try.
Yeah.
and
Remove the blank Senator White and leave us with the
Yes.
real Senator White.
Okay.
That's the
I hope
evil
this
Senator
works.
White and the good
Okay.
Senator.
Hey, you did
There we
it,
go.
Peggy. Great job.
Thank you. So,
Peggy's gonna go to work for IT next week.
Keisha, I apologize for, I am having device issues this morning. But so I missed the part, and I did read it last night, but it was, the language was a little too legalese for me, so I appreciate your explanation. Is there a difference between purposeful misrepresentation and just reporting something that in the moment seemed one way and wasn't another way? I mean, is there a difference between kind of purposeful and just making a mistake?
I think it's a good question for the state's attorneys. I only have examples, and it would still rely on the corroboration or the sort of clarification from probably other witnesses or officers. One example, was saying that someone was slammed to the ground, but had their hands free, were not handcuffed, when in fact they were handcuffed, which is a very different situation. So the examples that I've heard are pretty sort of clear one way or another. And I think there's probably some level of discretion that will always exist for a state's attorney to say they seem to be knowingly misrepresenting the information or not. But the examples I've heard are pretty clear. And if, you have, say, an officer say, I shot them because, they had a gun in their hand, and then there's clear body cam footage that they did not have a gun in their hand. I think that's still information that the public should know, regardless of, whether or not they knowingly believed that, if they thought they saw a gun in someone's hand. I think that's still valuable information for everyone to have, and not just take the word of the officer. I don't know if we're at the point, you all would know better if we have body cam footage from every incident in the state. But to the extent that we do not, we still should allow the public to know information about an officer's history of misclassifying information, to be able to access justice.
So, forgive me, reading the Digger article, Tarnished Badge, I thought that it was clear there are certain officers who state's attorneys just won't call as witnesses because they're not credible, or they've been proven to not be credible, and I often wondered how they can stay on the job. And Senator, the other bill last year, a companion to this bill 145, was the I can't remember the number. It came out of Senator White's committee. It was more on the decertification, other measures that can be taken to with law enforcement. Bryn, can you explain the difference between what this does and those officers who are no longer credible to testify on bills? I'm sure that, and doesn't the state already have an obligation to give all information to the defense?
So to answer your first question, for the record, Bryn Hare from Legislative Council. To answer your first question, I'm not sure I can answer it actually, because I didn't work on that bill in Senator White's committee. But I can tell you that there is existing common law that requires that the prosecution turn over certain types of evidence to the defense, and that includes what was commonly called as Brady material and Giglio material. And the idea with the amendment is really to codify those existing common law requirements. And you can look at the language. I do think it makes the requirement a little bit broader by the way it defines prosecution team, because it requires anyone on the prosecution team who has these types of evidence, the types of evidence that would tend to negate the guilt of the defendant, or the types of evidence that may undermine the credibility of a witness. If that information is available to anyone on the prosecution team, they are required to turn it over. So in that way, I do think it extends, it is a little bit greater of an obligation than what exists in common law.
Other questions for either Senator Rahm or Bryn? Okay. John Campbell, Executive Director of the State's Attorneys and Sheriffs.
Morning.
Good morning.
John Campbell, for the record, State's Attorneys and Sheriffs. I have to say I'm a little surprised on a couple of things. Number one, that this topic is on this bill, and again, also the timing of it. This is, like my understanding, is third reading. And the whole concept of Brady Giglio we could take a whole morning to discuss it, because so many people just misunderstand what the obligations are. This bill, I think what it does is it conflates the two legal obligations that we have, not just under common law. We have it also as under professional rules of conduct number 3.8. They have a specific rule just for prosecutors that states exactly this about that we have to disclose information. So there's a professional conduct side. Additionally, and as Senator Benning knows, there's also Rule 16 that is the discovery rule. And it tells you exactly what has to be disclosed, which is all Brady material. The Brady material is material that tends to negate the guilt or exculpatory evidence that would be beneficial to the defendant. We have an ongoing obligation to present that, to provide it to the defense. The Giglio aspect of this, what's called Giglio letters that everybody has been referring to, that goes to the impeachment side at a trial. So if we know that there's an issue, not just with police officers, this goes with all witnesses we have. If we know that there's something about that witness that would go to their truth or their veracity, or just to indicate any type of bias, then that information we send in a letter to the defense counsel and advise them of that. And also, let me just say too, and all due respect to Senator Rahm, I don't know what state's attorney she's talking to, but this is a mandatory requirement. This is an obligation that's mandatory under common law, under Rule 16, and under professional rules of conduct. There's no discretion here. We have to disclose this information. If not, we're subject to significant sanctions, both by the court and also by the Professional Conduct Board. And I believe, this is another thing, you probably should check with the Professional Conduct Board to see if anybody's ever brought, or how many complaints have ever been brought for under 3.8. So, and again, the state's attorneys, again, I don't know who's been spoken to, but We every summer when we do our training, this is one of the major things we do. We do it repeated all the time, especially for the new individuals coming in, that they have these obligations. It's something that in criminal procedure in law school, I mean, you learn this. This is nothing that's new. This is nothing that's avant-garde. This is something that is a basic requirement in criminal law. My concern with this language, again, it conflates two specific areas that are already dealt with across the board, and then kind of broadens it. And as such, there's going to be a conflict with what we already have in criminal rules. In fact, what concerns me is I believe that the way this is written here, because it does not include the exceptions that are there for certain, and you'll understand what exceptions, why they're there. But there are exceptions that would probably require us now to disclose the names and identity of confidential informants. I think it would also question whether we have to deliver work product and also the victims' names and addresses. These are all exceptions that are set out and in the rule 16, but it's not here. By trying to do this quickly like this, I think you all are making a major mistake that you're going to end up having unintended consequences across the board and possibly doing more harm for what we're trying to do, and that is to have more transparency than you realize. I wish I had more time, but I just saw this amendment last night. I'm more than happy. I know I've spoken to many of the state's attorneys last night who were very concerned that they're also really shocked that this was even brought up because of the fact that we do have the continuing obligation and that this is something that they do on a regular basis.
Whether they're shocked that it's been brought up or not, any senator has a right to offer an
I
amendment to a bill. I mean, you know that. And whether or not it's germane to the bill is a question that Bloomer has to answer, right, if somebody questions it. Right? So I just, it is obviously a fairly complex area of the law that many of us are not that familiar with. But I'm not sure we're getting at the prosecutor. That's not, I guess it's a question for Senator Rahm or Bryn. Is this getting at the prosecutor or the police officer? Because if the prosecutor is already required to give this information, what happens if the police officer is not given that? There's a case, ironically, there's a case in the Bennington court yesterday where they went to the Supreme Court because they believed the police officer got the wrong person. And the identity from the witness had to do with, did the person have a beard? Did they have a tattoo or a goatee? And did they have silver caps on their teeth and that sort of thing? And the guy that they got doesn't appear to have that. So there was that question. And I don't think that was the prosecutor. I think it was the police officer who did the investigation. So does this go to the police officer or the prosecutor, or get at the?
Oh, well, I think the answer is really both. The obligation is on the prosecution team, which can include an investigative officer who's working on the case. But I think that the idea behind at least the Giglio file portion is to codify the requirement that the prosecution team turn over any information that might indicate that one of their witnesses could be impeached on the stand. So I think in that way it would apply to both.
Thank you. That's helpful. Any comment, Senator White?
And would it also apply to witnesses, as John, I mean, not just police officers, but if I'm a witness, it would also apply to me?
Yes.
Okay.
It would apply to any witness who the prosecution is using to establish an element of the crime.
Okay. Any questions for John Campbell? Thank you for being here on short notice, John.
Thank you.
Julio Thompson's here representing the Attorney General's office.
Yeah.
Julio, thank you for being here on short notice. We really appreciate it.
Thank you. I'm just trying to get my my video in order. I'm getting it
I
up on
know.
the screen right now.
It's
Folks can
been
hear
a,
me?
yeah, we can hear you. We can't
Okay.
see you. It's been a problem this morning. Had a lot of folks have had technical difficulties.
Well, for the record, my name's Julio Thompson, Assistant Attorney General, Director of Civil Rights Unit. Our office, the Attorney General, certainly agrees with Senator Rahm and others that have spoken that the duty to disclose information that could be used to impeach a witness in a prosecution isn't a discretionary duty. It's a constitutional duty that's been around, that's been articulated since the Giglio case in 1972, so almost 50 years now. As I heard, I received a copy of this bill yesterday, and as I read in subsection A, and as I heard Ledge Counsel say today, that the point of the bill here is to codify the existing duty in statute for the purposes of ensuring that there's no mistaking that this is a duty and not a recommendation. And I think that from the state's attorney's office, that reference to Rule 16 of the Rules of Criminal Procedure, which are issued by the Vermont Supreme Court, I think is important. That Section B of that does identify in a way the Giglio rule, as well as the exceptions that have been recognized under it. For example, with confidential informants, there's a procedure by which, under the rules of evidence that the Vermont Supreme Court issued, where the court would have its own private hearing where, without jeopardizing the disclosure of a confidential informant, to see whether the information that's to be provided is material to the evidence of the case. It is an objective standard that the prosecutor has to follow. The rule is that you have to disclose if there's a reasonable possibility that disclosure of the information could undermine their case. Not a certainty, but also not a remote possibility either. So to the extent that the rule is articulating the existing standard, I think we're supportive of that, because I have not been involved in any discussions about Giglio or anything like that. But if there is this idea that it is something that's a should rather than a shall, then that's something we would certainly want to eliminate. With respect to this issue about the scope of the rule and the prosecution team extending to the police, I guess I would clarify or expand upon what you've heard from Ledge Counsel about whether that duty extends to people who are not just the prosecutors. And that's already existing law. In 1995, there was a case called the Kyles case, Kyles v. Whitney, saying that information that's known only to the police who are part of the arrest team and part of the investigation is also subject to that disclosure rule. The idea being that due process doesn't want to, or the court doesn't want to have a system set up where the prosecution team kind of sticks their head in the sand once they've got the evidence that's favorable to their case. And so it indirectly mandates the prosecutor to inquire of the law enforcement agency, to affirmatively look for that information to get it. And then I guess the discretion that is involved here is whether the prosecutor is going to use the evidence. The prosecutor, gets to decide what witnesses they're going to put on. And Giglio really has to do with information that would be used to impeach the credibility of witnesses. So I'm not sure. I don't see an expansion of the existing rule here, which I think which makes subsection A, I think, consistent. It's basically an intent to codify the rule. I think that to avoid confusion, it would be helpful perhaps to indicate not only that this confirms, the obligations under this case law, but also make it sure that have some reference that it's not intended to override the more detailed procedural rules that are set forth in Rule 16, both under the federal rules of criminal procedure and under virtually every state's rules of criminal procedure. That's where the finer details about what do you do about, things like attorney work product, that privileged material at the federal level. There are exceptions relating to national security exceptions that may come up in federal cases. So
unfortunately, Bryn has to leave, Julio, so I'm gonna say
Okay.
thank you, Bryn. And
thanks, Bryn. So I think it would be helpful if the committee's going to go forward with the amendment to ensure that there's some reference, some kind of preservation language or savings language with respect to Rule 16.1, because I didn't hear today or read in the text any intent to undo what the Supreme Court has done in Rule 16 for a long time. So I guess that's where I would stop, and if there are questions, I can answer that.
well, Marley has a question. I thank you. Are there any questions for Julio? I'm sorry, I gotta go take care of a dog who's barking like crazy. Senator Bruce, can you take over for a minute?
Sure.
Thank you.
Do you want Commissioner Sherling next? Commissioner Sherling. Are you here to comment on the draft?
I was, good morning, Senator. I was here initially to listen in and comment as necessary. We've only had the bill for an hour and 10 minutes or so, so a little disadvantaged. Just briefly in listening to the testimony, a couple things stand out. I agree with both what Julio and John Campbell have said. I'm a little concerned about moving swiftly with something that is so technical. For the committee's background, I was a criminal law instructor at the police academy for, I don't know, a great many years, from the mid to late 90s through the mid 2000s. And I can tell you that embedded in the criminal law curriculum are discussions of both Brady and Giglio and the mandatory nature of reporting exculpatory evidence in the case of Brady, and reporting issues of credibility in regards to Giglio. And it's something that we deal with on a fairly regular basis annually in conversations with prosecutors, ensuring, I think to a fault, for the most part, I think what you see around the state is, in many cases, over-reporting of Giglio issues in particular, to ensure that the prosecutors got the full array of things that may be necessary to disclose under those rules. So that's just a little bit of cursory background on the fly, on short notice. It strikes me in at least preliminarily in listening to the initial testimony here that one solution to this may be to codify in a more simplified fashion, to point to the rules of evidence and to point to the Brady and Giglio decisions, and as the current draft says, their progeny, and just state that those things are mandatory for law enforcement organizations to comply with, that it's not just something that applies to prosecutors, because by extension, it's kind of meaningless if it applies to prosecutors, but you're not getting reports from law enforcement agencies. Again, I'm not aware of that happening, but if you want to address this in statute in the future, there may be a more simplistic way to do that and ensure that all of the complexity that goes with both the rules and the existing case law are preserved and not harmed in any way. Those are some preliminary thoughts, but again, it is very difficult to digest something this technical with so many potential implications on the existing way that business is conducted on on an hour's notice.
Thank you, Commissioner. Dick, you're muted.
Thank you. I appreciate that, Commissioner. I'm feeling like we're a little bit, that this is an issue that deserves more attention, and Senator Rahm, we're willing to introduce a bill on it. I think it should be addressed, but I don't know if H-145 is the place to do it at this point. But the credibility, I mean, it goes back, bills that we have passed in this committee regarding innocence protection, the use of lineups, all of those things are all related to making sure we get the right person and that we've done it correctly. And Commissioner Sherling is to be commended, I think, for, I will say in my district, well, a lot of people are upset that a certain trooper has been charged. The fact is, it was members of the team that was there that made the case, and rather than the defendant claiming something. Defendant claims he doesn't even remember the situation. He was really intoxicated. But there were, I think, 3 state police officers there, and the other 2 were the ones who felt that the officer who struck the defendant had done so in a manner that wasn't in terms of unnecessary use of force. Senator Benning, I know you have to run.
I do, and I wanted to make a couple comments before I did. Senator Rahm, I appreciate this attempt. As a criminal defense attorney, I'm always into making sure my clients are covered in every respect. As I think about the history of my own business, I've probably represented over 2,500 criminal defendants through the years. And I would say that probably 95.4% of them have, when walking through a police officer's affidavit, stopped me and said, no, the officer's lying about what that is. And in my own head, trying to think through this bill, I feel like I haven't had enough time to wrap my head around how that would all factor into what's going on here. And just so you know, for practical purposes, I practice in St. Johnsbury, in Guildhall, and in Newport. And in all 3 of those cases, maybe not with Vince Luzzi, because I don't think I've ever received one, but what we'll call a Giglio letter that involves a specific police officer has traditionally been sent by the prosecution. And it is shocking when you get it, because the prosecutor is letting you know that they have no intention of using this person either as a witness in the specific case or in any future cases going forward. So on the one hand, I'll compliment the state in taking that responsibility pretty seriously. The only nervousness I have here right now is I haven't thought through the process. If I call the state's attorney and I say, well, my client says police officer so-and-so lied on this occasion about this event, at what point does that information get factored into what you're trying to do here to codify something? And I really personally feel like, as a criminal defense attorney who totally supports your bill, that I would like to be able to flesh that out in my head before I leap to any conclusions. But just so you know, we hear a lot about what goes on around the United States and how police officers have been kept secret for one thing or another, as we do priests and a whole lot of other things. But in Vermont, at least in my criminal experience, police officers and prosecutors have been very good about trying to make sure any exculpatory information is provided, or even a potential for that is addressed. Right now, I feel like there's a system that is working. And if you're going to codify something, which I have no problem with, I want to make sure even every possible base that I've experienced has been covered, and I don't feel like I've got the ability to think that through between now and when this bill gets read for the third time. Which I have to say, I have to leave. I may not get back to have it during its third reading, so I don't even have that time to digest this. But for the committee, should we go to third reading and something comes up that would be a problem, I would respectfully ask that the bill be passed over so that I can come back and participate in the process before third reading takes place.
Will do. Commissioner Sherling, you have your hand up.
Thank you, Senator. And in listening to Senator Benning's comments, it struck me that I left out a critical piece of background, which is that in the two agencies that I've been most intimately involved in both Burlington and with the state police, when an officer is found to have a veracity issue, in other words, they lie in an official account of anything, whether that's an affidavit or something else, that is fatal to their career. So it should be a rare occurrence that Giglio letters A, occur, and then B, that there are future cases involving that particular officer, because while I can't speak to every agency in Vermont and their practices, for the most part, in the agencies that I'm familiar with and the ones that I have worked in, veracity issues are fatal. And we tell people that in those academy classes that I described as well, that your word is the most important asset that you've got. If the prosecutor can't believe you, if the court cannot believe you, you are absolutely useless to the criminal justice system. So you must report all facts known to you, including those are exculpatory, and your veracity must be maintained throughout your career to a fault. And while that doesn't always happen because we employ humans who are flawed, that is stressed and re-stressed from the time people are in the academy forward.
Julio, did you want to comment?
Mr. Chair, may I say
Yeah.
one thing before
Sure,
Senator?
please do.
I just want to say before Senator Benning has to go, because as a colleague, I know how stressful it can be if you're the reporter of a bill and you don't know what might happen on third reading. I did tell the chair and the vice chair that if it's the will of the committee to keep looking into this issue and getting more information before bringing an issue like this to the floor, then I would absolutely honor that and not push for an amendment today or even next Tuesday, because that's not necessarily enough time to cover all of your bases. So I just didn't want you to leave feeling like you might have to hear this via, some other means later today.
I appreciate that,
Senator.
My colleagues are fairly competent in this area, actually, and sometimes they scare me because they know more than I do. But I think the issue is certainly a good topic for conversation. I would hope that you understand that and that we not try to do something too quickly because it may have unintended consequences. And I haven't even thought those out yet, even though I support this concept.
Thank you.
Senator White and then Julio.
So I was just going to say that it seems to me that all of us are appreciative of the introducing the concept, and that and when I think about how much time we spent talking about the word feasible and how little time we have to do this, I personally would appreciate this not being added as an amendment to the bill, but coming in as its own standalone bill and really digging into it and taking testimony. So I appreciate Senator Rahm bringing it forth, but that's my sentiment. And I know that we're running behind time, so I thought I'd say that so that maybe we didn't need to continue discussing it.
Julio, did you want to comment?
Yeah, before I left today, I just wanted to address something that Senator Rahm mentioned earlier when she spoke about this idea of a registry. So as I mentioned earlier, under the Kyle's decision, the prosecutor has an affirmative duty to go look for this evidence from the folks, including law enforcement, that are part of the investigative team. Some of the issues that were raised in the newspaper article, and my only source is the newspaper article and the attachments that they provided, is that, there one county I mean, officers move from department to department, and there's no, I think at least it was asserted in the article, there's no, currently right now, no easy way other than to just pick up the phone and start making calls to find out whether an officer has something in their history that might tend to impeach their credibility, like a sustained finding of dishonesty, for example. And so I think that irrespective of whether the committee goes for this amendment, and I think, as I said, we absolutely support making sure everyone understands that they have to follow the Giglio standard. But that one thing that might facilitate or to make sure that the prosecutors are making those disclosures is to make it easier for them to find that information. Because under both just for confidence in the system and also for the individual accused, under Giglio, you don't have to show that the prosecutor intentionally suppressed the information. It's if they, even if it was inadvertent, but it could have undermined the confidence or reasonably undermine the confidence of the verdict, then it's a violation. And so making it more difficult or making it less likely that mistakes or oversights would happen is something that I think that we would look forward to working with folks on. And like I said, we'll do it at whatever time the committee wants to do. But again, it is crucial. And Senator Rahm pointed out, as well as Ledge Counsel, it's not just the prosecutor's office, it's the team on that. And that extends not only to the investigative officers, but in some of the cases you see reported nationally, forensic officers. You've had cases in other states where lab technicians have been found to engage in conduct that's not appropriate, and you can read in the newspapers or in the court reporters about disclosures that aren't made that may have undermined confidence in the physical evidence, not just eyewitness.
Massachusetts has had a huge problem with that recently.
Yeah, so
A number of cases have been dismissed, or even people who were in jail have been let out because of the falsification of some lab stuff. Senator Ron?
Well, I just wanted to say, Mr. Chair, you've given me and this issue a great deal of time for the end of session and for the other work you have to do today. And I appreciate other senators raising that, this is important to us building trust and credibility in our sworn law enforcement officers so that all Vermonters can feel safer in their presence and having them in their community. So I do look forward to getting you a bill and doing some of the work we've discussed today, so that that bill can be considered in a more robust way by the committee. And I do appreciate all the time you've given this, because it's hard to have a conversation about reasonable standards and law enforcement conduct without talking about these critical issues of credibility and eyewitness reporting. So really appreciate your time, and I will not ask the committee for a vote or anything like that.
I think it's the sense of the committee that it's a topic that deserves to have full-blown hearings, and I would appreciate. I don't think it can happen this session. I think it'd be something that we would certainly put foremost next year in this committee if we're all still here. Well, wait a minute. This is the second year.
I was going to say, I hope you all are still here, but
sorry. Yeah, I got a little confused about which year it is. So I would think this would be a topic of importance, but I also think the topic of that Senator White has worked so hard on in terms of the decertification of officers and having information when officers go from one district to one police department or agency to another is foremost. And we went through that with teachers who, and obviously in the Catholic Church, they have the same problem with people from one place to another to continue to do things that were appropriate. Thank you very much, Senator Ron. Appreciate you being here.
thank you.
And Julio and John Campbell and Commissioner Sherling and others, thank you for being here on short notice. Really appreciate it.
Thank you, Mr. Chair.
We're gonna switch gears to the bill on, and I can't remember the number, Michelle, so it's the markup of in committee discussion of the bill that, what is the number of the bill?
183.
183, thank you. Oh, yeah, right, now you get upset. 180, which is a bill dealing with,
Michelle, thanks.
I made a decision and this bill has a lot of reasonableness about it. Still some areas where I have issues. And I'm trying to go back to some of my notes. Oh, okay. Needs to have the totality of the circumstances taken into account. Remember that discussion?
Mhm.
And then, so why don't we go right to the beginning and see if there's any markup. Okay, and right at the top, consent means words or actions by a person indicating, and we want it currently knowing, and we wanted to add person knows. Remember that?
I'm not sure exactly what you're talking about there.
Mr. Chair, I think the discussion, as I remember it, was about whether we should swap that definition out for a more,
We have a redraft, right?
We do?
Redraft?
No,
I thought we
there's
were.
no,
thought we were-
I don't think we had moved that far on it.
Oh, okay.
Michelle had sent us a list of definitions of consent from other states and the federal
Mhm.
government. And we hadn't gotten back around to that list.
right. So I think, yeah. So I showed you the comparison with the federal definition and Senator Sears, the totality of the circumstances. That's one piece I didn't originally include that I can put in.
Right.
And I think one of the things that kept coming up before was kind of a focus on, or people were concerned, well, that there's a lot in there that says what consent isn't, but not necessarily what consent is. But if you look at all the other definitions and the other jurisdictions and stuff, there's a similarity in the elements of the short definition of what consent is, because consent can be so many things. It could be
We're having a break.
it could be words, it could be a yes, it could be a turning towards someone and embracing them instead of pushing them away. It's all factually based. And so that's why when you look at the other jurisdictions, you'll see just kind of the general statement of that it's voluntary or knowing, or there's words or actions that indicate that it's voluntary, but then it'll specifically say like someone who's unconscious, someone who's asleep, someone who doesn't have the mental capacity, someone who doesn't have the physical ability to resist, things like that, because that's much easier to articulate and put in the law as opposed to the thousands of ways you could show an expression of consent.
So may I ask a question? Doesn't just the statement that you made it just a little bit before when you said it was the statement that you said right before, if someone is sleeping or unconscious or incapable, just by word or attitude or action. I mean,
Mhm.
doesn't that define what consent is? I mean, you can do it by action or attitude. It doesn't have to be by word.
Right, and the
Yeah.
definition as it reads under current law says means words or actions by indicating voluntary
Consent.
agreement, and then this proposal just adds the word knowing.
Well, on Jeanette's point, there were a couple of the definitions that you sent us that I think used the word attitude.
Mhm.
And then the Oklahoma definition said something like clear, unambiguous, enthusiastic. There were sort of adjectives.
Don't require enthusiasm.
Well, it was there were descriptors around the attitude or the words.
Do you want me to pop up those other definitions from other?
Sure.
Would that be helpful?
I think those descriptors are pretty, I mean,
Well, I'm just saying that there are other definitions that go
Right.
beyond words or actions.
right, I know, yeah.
The Oklahoma one actually seemed pretty reasonable to me.
Oh, where do we have it on our website?
Here we go.
Oh.
Oklahoma. Here's Oklahoma.
Oklahoma.
Oklahoma. 113.
Affirmative, unambiguous, and voluntary.
Oh, but not enthusiastic, okay.
Not enthusiastic.
You hope for enthusiasm.
But, words or actions seems to me just to defer the question. Whereas this is attempting to go at least a half step toward defining what those words or actions would need to look like.
And unambiguous could be pretty ambiguous in itself, but
Well, it's better than what's in the House version.
Well, I think if you look at what's in the House version, it really is just adding one word to the existing definition. And because there is case law built on the existing definition, I mean, I don't know, you probably want to hear from the witnesses about whether incorporating some entirely new terms there might work at cross purposes for you. I don't know.
Well, then why didn't they just leave it alone? Why'd they change it?
I think the testimony's been that you don't need to have knowing in there. You can leave it the way that it is and just that it's voluntary, because I think that there's an aspect of knowing that's implicit in voluntary. I think it's just a little clearer to put there that it's knowing. But
I understand what people are trying to get at here. It's a horrible situation. The examples nationwide are so warrant. But yeah, I think this. I like Oklahoma. But you're saying if we use Oklahoma, we confuse case law.
I don't know. I would just, maybe recommend you hear from some of the practitioners.
Yeah, I really. I'm fried.
Yeah.
To be honest with you, this stuff is.
I mean, when I look at the Oklahoma in B, when it says under duress, I mean, what does that really mean? Under duress, you might be under duress for a lot of things. It doesn't say.
Well, I was just referring to the definition of consent, not the pieces under, but
Okay.
I agree with the chair. I feel as though, it's not unusual for the House to put us in a position where we get things that are controversial or tough to deal with, and we have no time left.
Right.
So I feel like this bill needs more work.
Yeah. Yes. I mean, it's,
Mr. Chair, has there been
Yep.
any talk about whether morning committees shut down?
I'm unclear about what's going on this year.
Okay.
Well,
I'm
I
planning
think
to
we-
meet next week.
And we still don't even know if we're leaving on the 15th or the 22nd or some date in between, I think.
Well, all right. So
I mean, is there any way to simplify this with regard to just the drugs or alcohol, or? And that's where the problem, I think I've heard, is in terms of, people engaging in sex with someone who is drunk and they didn't give consent.
Alice, that's elsewhere in the bill. It's
Right.
within that definition.
Yes. Is there any way to just go there?
well, I think there's certain things here in section 1 and section 2 that we could do. I think where some of the problems that I have come into the trial court procedure on consent. I don't think that's part of my problem. I don't know what an expression of lack of consent through words of conduct means. There's no consent. And I don't know what that means. And Joe felt that in 1, the lack of verbal or physical resistance does not constitute consent. Joe felt that shift the burden to the defense. I think part of the problem is with section 3.
Yes.
I might just,
So Sarah Robinson has something.
okay, thank you I'm trying to, yes, Sarah.
Good morning. Thank you all for the conversation. Just wanted to, thank you for the good discussion you've had this week and last on this bill. I know it is complicated and there's a lot of implications, both in terms of the practical application of any of these changes. And I just wanted to lift up and just say from our perspective that I think some excellent questions have been raised. And if the committee would feel more comfortable or would be interested in a small group working on some of the particularities around the definition of consent or the language in sections 1, 2, or 3, the network would certainly be supportive of that. But we do believe that the other sections of the bill are important and timely, and we certainly wouldn't want to see those not be able to move forward around concerns around sections 1, 2, and 3.
And so for you particularly, it'd be section 4, the data collection and reporting, and section 5, the intercollegiate sexual violence prevention.
That and the related appropriations in section 7, which are to fund the Intercollegiate Council and also to support the forensic nursing program to expand their services beyond emergency rooms.
Can you tell me where this is on our web page? Because I'm just trying to find it because I'm at a different computer this morning. So I don't have the hard copy because I had
If you go to documents and handouts.
Yeah.
And then you go under bill.
Okay.
And you pull up the bill, all the documents for this bill will be there. Drafts and amendments would be everything that Michelle would have sent. And then there's witness documents.
And it's 183, right?
Yeah.
Got it. Okay, thanks.
No problem.
Because I had, I'm trying to think of, Sarah, your comments about the task, I don't think it's called task force, but the intercollegiate
Prevention Council, yeah.
Yeah, that I got some comments and I'm not sure where they came from about the word developing and
Is this about best practices?
yes, about developing, and it sounded like they were going to tell everybody what the best practices were. And I know, it came from the legal counsel at UVM. And they had suggested changing just like 3 or 4 words in there.
I did see that posted on the committee's web page, and we would be fine with that.
Okay. Thank you. I was trying to remember where it came from. It's been so long and so many other things in between, but.
What that is, I don't remember hearing from UVM.
I think I forwarded, but I can right now anyway. I will find it for you.
Okay, will you just email it to me?
I'm going to right this minute.
Thank you.
In the meantime, Rory has a comment. State's Attorney Thibault.
Good morning. For the record, Rory Thibault,
Morning.
State's Attorney for Washington County. Thank you for inviting me back again. I certainly understand the struggle of dealing with these definitions. Even as a practitioner with 15 years of experience, I still have to go back and read this definition every time I handle one of these cases in court or make a charging decision because it's critically important. That said, I share both the view of Senator Sears and Senator Baruth that really the Oklahoma definition, or particularly Colorado, I think are a little bit more clear and more relevant to our modern application and conception of what consent is and what it ought to be in a legal context. With that said, if the Colorado or Oklahoma definition of consent were adopted, I view that the trial procedure language in Section 3, particularly parts 1 and 2, which appear to be most problematic, would be obviated based upon the more comprehensive definition. I also agree, as Senator Sears previously pointed out, that directly incorporating into statute consideration of the totality of the circumstances is appropriate. So my recommendation, and I understand the exhaustion near the end of the session and a complicated bill, this may get passed on, but if there is any desire to advance this, my recommendation today would be to adopt either the Colorado or Oklahoma consent definition with the additional language of incorporating the totality of the circumstances and then striking subparts 1 and 2 from trial procedure, really leaving the things that are more clear or uncontroversial, which would be submission resulting from force or threat of force, or placing another person in fear is not consent, incorporating and noting that rape shield evidence can't be used to prove consent, a sleeping or unconscious person can't consent. These are all fairly obvious. And then the remaining language of trial procedure really speaks to what Senator Nika pointed out, which is the really core issue here, which is alcohol or drug-induced sex assault. So in that sense, trying to be precise with a clear recommendation of how I think the bill could advance and meet and address the concerns, which I think are appropriate. But certainly when looking at Vermont's now nearly 40-year-old definition of consent versus what other jurisdictions have done, you can see there's a lot more language trying to describe that, whether it's the affirmative or unambiguous. And I think that's helpful. And it, again, would take us from the regimen of having to have a very open-ended definition of consent that we then have to go back and prescribe what is not consent versus just a better definition up front where we don't have to carve out so many exceptions or clarifications to address those rape myths or other things that we don't want jurors considering. Thank you.
Thank you very much. Senator Baruth.
I appreciate the network's suggestion that this could do with more work in the off season. I think that would be all to the good, and Rory's suggestion I think would make sense, but in conjunction with the advocates over some months, it might gel into something that we could take up next session more easily. I support the last section in this bill, which is the forensic nurses and the funding for that program. I would like to suggest something else because, to be very honest, I don't support the Prevention Council. It's a 7-year council with a large number of people, and what it's tasked with doing is, in essence, meeting and sharing best practices, which they can all do now. So I don't know how obligating the state for 7 years to pay for that process makes any sense. It reminds me in a way of the pre-K through 16 council, which I was on, which was put together in statute, met a certain number of times during the year, but didn't have any specific task or charge. And so it became more or less a professional social time together, which is not a bad thing. It's just that the charge here is sort of extremely general, but in terms of a commission or a committee, it's extremely long-lived. It's there for 7 years. So I would support pulling the piece on the funding the forensic nurses out of this, putting it directly in the budget, and then having the rest come back to us next year.
I'm going to suggest that we not give up on this at this point, but I think it's a good suggestion, at least getting the 40,000 into the budget. Forensic nurses, we need that. I'm going to suggest that if State Attorney Thibault and Michelle are willing to work together to redraft 1, 2, and 3 as just described, using the totality of the circumstances as well as the Oklahoma model, and see where we're at, and then come back next Wednesday to this and discuss what it looks like. And but taking, as Senator Baruch just offered, I assume it's got to be in the House budget section.
The last section.
Section 7.
Is it?
Yeah. Well, section 7B is actually it. Because A is appropriation for the staffing in the Collegiate Sexual Violence Prevention Council in A. And B is the appropriation for the nurses.
Is it already in the House budget?
I would assume it must be, because if they passed the bill, they had to put it in the budget.
Oh,
Well, did they?
Well, you can't pass a
Sarah's,
bill without
Sarah's
putting the money in
shaking
the
her head
budget.
yes.
Sarah says they did.
Sarah's
So,
saying yes.
There's 3 of us on this committee that would go to the Senate Appropriations Committee and urge them to add the 40,000 or to concur with the 40,000 in the House bill. What I want to do is see a redraft next Wednesday, and David and anybody else is welcome to work on that. That would simplify this thing. I think it's become extremely complicated in 1, 2, and 3.
I can do that and get that out to everybody on Monday.
And then taking 7B out, assuming that goes in the budget. And then you would have a decision to make about the council. And did anybody, I have a note around the data collection. How much will it cost and can they do it? Sarah?
Yes, so Major Jonas did testify on that section of the bill to all that will fall within the existing resources that the Department of Public
Right.
Safety has with their contract with the Crime Research Group. And I would just note that that's a very important section from our perspective. So we would certainly hope that that can remain in the bill.
So we would have a debate on a rewrite of sections 1, 2, and 3. Decide we're going to keep sections 4 and section 5 in. And if you keep section 5 in, which is the Intercollegiate Violence Prevention Council study, you'd have to decide in the appropriations. And by the way, oh, okay, the repeal is actually part of section 5.
Would you like me to include the UVM suggested language in the council just so you can see it and then you can
Yeah.
decide whether or not you want to include it?
Yeah. Yep. Rebecca, did you have a comment? I'm sorry.
I did, thank you.
Rebecca Turner, the appellate, the chief of appellate division of the Defender General. I got to get these titles right.
No, that's fine. Thank you. Senator Sears, good morning. Attorney Rebecca Turner from the Office of Defender General. I appreciate the committee's treading slowly in this area and hear really the struggle of how to frame and frame this statute in something that captures all of the nuances and subtlety in individual cases, which we know happens in real life. Effectively a totality of the circumstances analysis. I just wanted to reassure or make sure it was communicated to this committee that current case law has that as the test. That is why it is not defined in these categorical absolute rules, but as the statutes uses, captures it with the words may, right? Again, any one of these are and may be relevant for a factor of assessing consent. It's just very dangerous when you try to fashion a rule that has absolute situations where there will not be consent. So I just wanted to point that out, that the current law is not so confusing. It actually is exactly what I think this committee is struggling to do, is find draft language that captures a totality of the circumstances test as envisioned. If anything, the definition of 3251(3), this could all be simplified in the sense of consent means words or actions by a person or any other, or the totality of the circumstances, inject it there, and then leave the rest of it as is. There is no problem, again, with this current statute. The Oklahoma reference, I'm sorry, I'm just seeing that here. I appreciate if Michelle, or if it could be posted, the comparative state by state definitions. I didn't see it. But looking at that briefly, even the affirmative and on language, that is a departure from our current precedent. So I just wanted to make sure this committee knew that as well.
Okay.
Peggy, is that document of the statutes out on the website? Because I gave it to them like a few meetings back.
Yeah, it should definitely be on there. If you go to look up the bill and then go to, probably it's under drafts because it's something you sent, or witness testimony, but any documents for the bill should be up there. Do you want me to try and find it?
Might be helpful.
What was the name of it, Michelle? Do you remember? Oh, you're muted.
Michelle, you're muted.
I'm going to share my screen real quick with you guys to show you. That's okay.
Right.
Let's see, hold on.
I think you would have titled it something like consent statutes from other jurisdictions or something like that.
So I'm at documents and handouts. I went to the bill. This is 183. Right here. So these are all the, which one do you think it is? Comparison language to federal law?
Other state definitions of consent, Thursday.
Okay.
I see it. Thank you, Michelle. Thank you, Peggy.
Sure.
I'm gonna ask, I think that's helpful. So I want, moving right along, Peggy, I'm looking at next week's agenda. And I see we have H-133 scheduled at 10:15 a.m. on Wednesday. And I think what we would do is put this bill in at 10:15 if Michelle is available then.
Okay.
And
So-
move at 10:15 to noon on this bill. And move H-317 to Friday. Because hopefully by then the House will have passed it or done something with it. You were gonna fit that woman from the Human Rights Commission.
Yeah, around 11:40
Yeah. And
on
so-
Wednesday.
Yeah, Wednesday. And then we'll have taken all the testimony on 133. We just won't have had a committee discussion or markup.
Okay,
I guess that would have to wait until May.
okay.
So Peggy, I'm booked in House Judiciary at that time on H18, but I have otherwise that morning available. So if you just work with Evan maybe and just share for the morning and could figure it out, and then because I don't know if they have to have, maybe they could move earlier and then you guys could fit me in at 10:15.
Or I could, do you want me to switch? Are you free from 9 to 10? I could switch the H-133 testimony to 10:15 to 11. I haven't invited anybody yet.
I believe I am. Hold on one sec. Yeah, I'm actually free until 10:30.
Mr.
Okay, well,
Chair,
that's good. Yep.
David Scher is trying to be heard.
Oh, thank you. David, did you want to comment?
Just briefly, Senator, I know we're near the end and discussing it next week, but thank you. David Scher with the Attorney General's Office for the record. Just wanted to note, as we prepare for next week on this, very much appreciate folks' really hard work on this, and State Attorney Tebow brings a lot of expertise, and appreciate his national research on this. Did want to note for the record, significant changes to the consent definition happening quickly would be of concern to our criminal division with respect to potential unintended consequences about how things might play out, given the fact that we do have an established body of case law based on the current consent definition. I'm just talking about the top of section 1 here. And so wanted to preview that may be, depending on how redrafts go, that may be a point of significant concern for us, but also wanted to say that we would have no objection to proceeding as the network suggested with respect to doing a longer look at what is now sections 1, 2, and 3 and making sure that we get these changes as right as we can without unintended consequences that might make currently viable prosecutions unintentionally more difficult. And so we'd have no objection to proceeding as the network suggested, and we do support the latter sections of the bill, although obviously I understand some of those will be discussed further, but wanted to put that out there for the record so the committee knows where we're at.
Okay.
Thank you.
Appreciate that. This thing is no slam dunk. I'm just trying to look at what this committee can possibly do to get a bill out. Senator Nitka.
I'm wondering if Rebecca could submit the words she suggested as well.
Okay.
If you could do that, please, Rebecca.
I will, thank you.
Submit your solution to Peggy, please.
Thank you, Senator Nick, I will.
I'm looking at trying to put together next week's agenda, Peggy. I don't see how we.
Well, if we know that or do you think we'll have another week? Could we do H-133 the next week if we get another week or
I
no?
have no idea if we'll get another week, but I'm happy to cancel all of 133 and look at that going into May. If we get another week.
What is 133?
The emergency relief from abuse orders and relinquishment of firearms.
Okay.
It's eating up most of the week, and therefore we would have time to do 225. We'd have time to, yeah. And Tuesday, I have a problem. I take my wife to the doctor's in Albany, New York, so I won't be here. So maybe it'd be better to, we need to look over S45. We need to have a, you know what, you could do if Eric is available Tuesday and he's doing the firearm bill anyway, you could move that 317 on to Tuesday, leaving plenty of time for this bill on Wednesday.
So Tuesday, 317,
Right.
Wednesday, 183.
Yep.
Till
At
10:30.
times that are available, well, at times that Rebecca, at times that Michelle is available.
Till 10:30. She's available till 10:30.
Yep.
Then that gives us free from 10:45 to 12. This is if we're getting rid of H-133 altogether.
Yep.
And what would you like me to put in there?
Well, I was going to move 317 to Tuesday.
Yeah. So we have free from 10:45 to 12 on Wednesday if we get rid of all of 133.
Okay. Yeah. That's fine. And then Tuesday, move 317 to Tuesday.
Yep.
And we'll figure out what to do from 10:30, from the time Michelle has to leave until noon on Wednesday.
Okay.
Okay. You and
Yep.
I can figure that out.
Yep.
Now let me get back to this week's agenda. This is complex. I'm making it more complex than it needs to be. All right. What would we do without 3 agendas? We're scheduled to take up hate motivated crimes at 10:15 this morning.
Yep.
Is there anything more on this bill? Thank you all very much. Why don't we take a 15-minute break?
Yes,
Come back
thank
at
you.
10:15. Yeah, thank you.
Thank you.